Good evening, everyone. Before we start tonight's webinar, we're going to wait about 30 to 40 seconds just to allow participants to join. Good evening, everyone, and welcome to tonight's webinar, Navigating Real Estate Through Divorce and Separation. If we could go to the next slide, please, Barb. Thank you. My name is Sasha Ferrone, and I am a family lawyer at KPA Lawyers. Joining me this evening is Iris Dowling, a mortgage broker, Bini Billimoria, a real estate agent, and Barbara Kay, a real estate lawyer. Barbara and I both work at KPA Lawyers, which is located in Mississauga at the intersection of Huron, Ontario and Matheson. KPA is what you would refer to as a full-service law firm. In addition to practicing family law and real estate, we have colleagues that practice in various areas of law, such as wills and estates, civil litigation, criminal defense, and small claims. During COVID-19, our firm is offering free consultations. If you have any questions with respect to family law, real estate, or any other area of law, you're more than welcome to book a consultation via Zoom or a telephone for consultation with one member of our firm. In terms of what you can expect for tonight's webinar, each of the panelists will give a very brief presentation about their profession in the context of navigating real estate through divorce and separation. After the presentation, we will then open the floor, so to speak, to answering your questions. You can ask questions in one of two ways. You can click on the Q&A icon that appears on the bottom of your screen and simply type your question. The panelists can either reply back through text in the Q&A window, or we can answer your questions live. The second option to answer a question is to click the raise hand icon, again, that appears at the bottom of your screen. Please note that this informational webinar will be recorded and will be published to the public to view at a future date. Can we go to the next slide, please, Barb? Thank you. So in Ontario, the rules about how you divide property depends on whether you are legally married or whether you are in a common law relationship. So when I'm talking about division of property, I'm not just referring to real estate. I'm also talking about the division of pensions, division of retirement savings, credit card debt. But for tonight's presentation, we will be focusing on real estate. Contrary to popular belief, property division looks very different whether you are a married couple or a common law couple that's going through a separation. So if married couples separate, it is automatically assumed that there is going to be what is referred to as an equalization payment that's owing from one spouse to the other. And I will discuss what an equalization payment is in the next few slides. In family law, individuals are considered to be family law if you are either living together for 1 year and you have a child together, or you are living together with your partner for 3+ years. Unlike married couples, common law couples are not entitled to this equalization payment. So if a common law couple separates, the general rule of thumb is what's mine is mine and what's yours is yours. So generally speaking, if a common law couple separates, you get to leave the relationship with any items that you brought into the relationship or purchased or acquired during the relationship. Next slide, please. So for married couples, there are two significant dates. There's the date of marriage, or what I like to call DOM, and the date of separation, DOS. So the date of separation for family law purposes is also called the valuation date. If a married couple separates, each party would need to calculate what their net worth was on the date of marriage and the date of separation. And the idea is that the spouse that has the higher net worth on the date of separation would pay the lower net worth spouse half the difference in their net worth. So by way of a very simple example, let's assume that one spouse is worth $100 on the date of separation. So we take all of their assets minus all of their debt on date of separation minus date of marriage, and their net worth, what they are worth on the date of separation, is $100. And we do the same calculation for the other spouse. And let's assume that the other spouse is worth $20 on date of separation. So we take $100 minus 20, that's $80. You divide that by 2, it's $40. So the spouse that was worth $100 would then make what's called an equalization payment to the other spouse of $40. So the idea here is that both spouses leave the marriage worth the same amount of money. They both leave the marriage worth $60. Next slide, thank you. So in order to calculate property division, both couples, if you're married, would have to complete what's called a financial statement, and it's a Form 13.1. And the financial statement lists all assets and all debt for the married couple on date of marriage and date of separation, and both spouses would have to complete their own forms. So on this slide, I've just taken a snapshot of one portion of the financial statement. And again, you'll see date of marriage. So in this case, March 1st, 2003, the spouse would have to list all of their assets and all of their debts on that date, as well as the valuation date, which is the date of separation. So on the screen here, I have the matrimonial home and I have a rental property. So a matrimonial home for married couples is the home that the spouses lived in on the date of separation. So depending on, the circumstances of the spouses, there could be more than one matrimonial home. So for example, if a couple owns a cottage property, there could be two matrimonial homes. There could be the property that they reside in, let's say in Mississauga, and their cottage property up north. So when it comes to matrimonial homes, they're afforded special rights and privileges. So for example, if one spouse is living in the matrimonial home and the other spouse moves out after date of separation, the spouse that continues to reside in the property cannot change the locks. So there's what's called a right of possession, and both spouses that are in a marriage have the right of possession. So they have the right to be in the property regardless of who is on title. You can't change the locks. You can't encumber the property in any way. So you can't register a mortgage on the property or line of credit without that spouse's consent, again, regardless of which spouse is on title. And if you look at the example I use, so let's assume that this matrimonial home in Mississauga was worth $300,000 on the date of marriage. And let's assume that one spouse, we'll say the wife, came into this marriage with this property, and the property was worth $300,000. And on the date of separation, the property then went up to $600. Because it's a matrimonial home, even though the wife came into the marriage with this property, when the property is divided in terms of calculating property division or equalization, both spouses will walk away from this relationship with $300,000 in terms of the value of the home. So when it comes to a matrimonial home, if a spouse brings this property into the marriage, they don't get the deduction or the exclusion. However, if it's a rental property, so let's assume, same example, the wife gets married, she owns this rental property that's worth $200,000 in my example on date of marriage, she gets to deduct the $200,000 because that was the value of the property on date of marriage, and that rental property has now gone up in value to $400,000 on the date of separation. So in this case, there's that deduction because it's the rental property. And so essentially, the thinking is that both spouses get to walk away with different amounts. So the person that comes into the marriage with this rental property worth $200,000, they would walk away with $300,000, and this other spouse would walk away with $100,000. Sorry if that's a bit confusing, but the idea is that you split the increase in value. So the rental property increased in value by $200,000 from date of marriage to date of separation. And so each spouse gets half the difference, whereas a matrimonial home, you don't get that. $300,000 date of marriage deduction, and that's why I crossed it out in the example. All right, and the next slide, Barb. Thank you. So when it comes to common law couples, as I mentioned previously, property division is treated very differently for common law couples versus married couples. So for common law partners, there's no automatic entitlement to equal property division or to a share in the family home. However, there is recourse for common law couples to make what's called a constructive trust claim in order to remedy unjust enrichment. So in order to prove that one partner in the common law relationship is unjustly enriched, you'd have to show that you and your partner were involved in what's called a joint family venture, and that your partner is keeping a disproportionate share of the profits of that joint family venture. So a constructive trust gives the beneficiary a right to the property in a particular asset, such as real estate. So a court can also award money in terms of remedying a unjust enrichment claim if one partner can prove that the other partner is unjustly retaining a disproportionate share of the profits of a joint family venture. And constructive trust claims are quite difficult to prove, and they're very, very fact specific. So in order to determine whether you or your partner were part of what's called a joint family venture, the courts would consider a variety of very fact-specific questions. And some of the questions that I have on the slide are what courts or what judges would ask. So was there a pooling of resources? So did both parties invest money in a business or a home? Did the parties have children together? Were decisions made jointly about the children or jointly about finances? How integrated were the parties' bank accounts, right? So did the couple or the common law couple, did they share bank accounts? Did they have separate accounts? Did the parties see their relationship as equivalent to being married? When it came to filing things like tax returns, did the couple indicate that they were in a common law relationship versus single? In general, did the parties prioritize the family unit over themselves? Did they make decisions such as relocation or change of jobs? Were they thinking about themselves? Were they thinking about the family unit? So generally speaking, the longer the relationship is, the more children there were between that common law couple, and the more integrated the finances were, the more likely a court is going to find that there is in fact a joint family venture, and that it would be unjust if one partner leaves the relationship with nothing in terms of a division of property. So if a joint family venture is established, then you need to show that your partner has profited unfairly from the joint family venture and is walking away from the relationship with a disproportionate percentage or amount of the profits. Specifically, you'd have to establish that you have, through your contributions of money or sweat equity or labor, enriched your spouse, that you suffered a deprivation in making those contributions, and that there is no legal reason for the enrichment. So that's kind of the legal test. And I think that's it for me. And I'm going to pass the floor off to Iris.
Hello, everyone. And thank you, Sasha, for such a strong start to our presentation this evening. My name is Iris Dowling, and I'm a mortgage broker. I assist people just like you to secure mortgage financing that you need. You may have worked with a mortgage broker in the past, and that's great. But for those of you who have not, I'll quickly outline a few areas of my service. So my services are free to you. I shop the market for the best mortgage terms and interest rates, saving you time and money. I don't work for a specific lending institution. I work for you, providing personal and professional services. I have access to over 65 different lenders and mortgage products, including most of the banks. For example, I have VIP status with Scotiabank and TD. I provide step-to-step guidance through the entire home purchasing process and right through to your mortgage renewal. I have flexible availability. I am a licensed expert and I appreciate your business. Next screen. Currently, Those who have been separated or divorced for 90 days or more are eligible for the first-time home buyer incentive programs. There are 4 main incentive programs that you should be aware of: the Ontario Land Transfer Tax Rebate, the Home Buyers Plan, the First-Time Home Buyers Tax Credit, and the National Housing Strategy First-Time Home Buyers Program. I will review them quickly, and if you have any questions, please ask at the end of our presentation or feel free to contact me directly. For some of you, this will be a review, but I wanted to be sure to discuss the current updates. So the 4 first-time home buyer incentive programs. Number 1, the Provincial Land Transfer Tax Rebate. As a first-time home buyer, you will be eligible for the Land Transfer Tax Rebate. This tax is prorated based on the purchase price and has a maximum rebate allowance of $4,000. This rebate is automatic at closing. If purchasing in the City of Toronto, there is an additional Toronto Municipal Land Transfer Tax. For purchases with prices below $368,333, there is no tax payable as it is completely covered by the rebate amount. Home Buyers Incentive Program number 2, the federal government's Home Buyers Plan. This plan allows first-time home buyers and those who are recently divorced or separated to withdraw up to $35,000 per eligible buyer from an RRSP to purchase a home without having to pay the tax at the time of withdrawal. Remember, the $35,000 does not have to be used solely for the down payment. It can be used for closing costs, paying off some debt, moving expenses, furniture, or any expense that is related to the purchase and the move. You have 15 years to repay the amount that you withdrew from your RRSP under this Home Buyers Program. Home Buyers Program Incentive number 3, the Home Buyers Tax Credit of $750. Through Canada's Economic Action Plan, the federal government has introduced a first-time home buyers tax credit. This is to assist with the costs associated with the purchase of a home, such as legal fees, disbursements, and land transfer taxes. You must claim for the $5,000 first-time home buyers tax credit in order to qualify for the $750 rebate. Next slide. The 4th opportunity is the National Housing Strategy First-Time Home Buyers Program, A Place to Call Home. This program offers a 5% loan on an existing home or 10% on a new built home of the purchase price to put towards a down payment. You must also have 5% or 10% from your own resources. This is a shared equity second mortgage. The government will share the upside and the downside of the property value. You do not need to repay until either you sell or until the end of the 25-year amortization period. The upside is that you can increase your purchase price by an additional 5 or 10% without increasing your monthly mortgage payment. This program is administered by CMHC, and keep in mind there are additional qualifying criteria. Next slide. In response to the anticipated marketplace declines post-COVID-19, CMHC has announced there will be rule changes effective July the 1st. They have announced 2 main changes. 1, the minimum credit score requirement will be increased from 600 to 680. This is the number on your credit report. And 2, they will be decreasing their qualifying debt service ratios, which means that after July 1st, you must have a credit score of 680 or greater, and you will also have an estimated 11% reduction in purchasing power due to the reduced debt service ratio. These changes apply on mortgages with less than 20% down and are insured with CMHC. Please be sure to note that there are 3 mortgage insurers in Canada, and CMHC is one of those 3. Next slide. I always recommend that a pre-approval be secured by a qualified mortgage professional like myself before you go house shopping. This will save you time and will give you confidence that you can purchase the property that you may be considering. Keep in mind that you can often use income such as child support, spousal support, and/or the Canada Child Benefit as qualifying income. The qualifying process will also highlight any concerns that may need to be addressed prior to closing on your purchase. such as securing a separation agreement or a divorce certificate, or if your credit score needs to be addressed. In the mortgage qualifying process, it is important to have a strong credit report. I understand that life changes impact credit and your ability to make regular payments. If you have any concerns about your credit or you'd like me to review it, I'm happy to do that at no cost for those who are participating in the webinar this evening. Next slide. Mortgages can be complicated. It's important that you understand the terms of your mortgage. The interest rate is also very important, but not quite as important as the term, which could cost you thousands of dollars in penalties if the term is not considered beforehand. Next slide. Knowing and being prepared for your closing costs is also important. This is the amount of the bank draft the lawyer will request you to provide to their office. You'll need to consider things like the PST on the lender insurance. I always provide my clients with a written expectation of the estimated closing costs so that they can be prepared. Next slide. Have a budget prepared for your home ownership costs. Anticipate and save for the larger unexpected expenses like a new air conditioner. And it always seems that the air conditioner breaks down the hottest day of the year, so you want to be prepared for that. Thank you for being a part of the webinar this evening. Next, I'd like to introduce you to Bini, Billimoria. She's an awesome realtor with RE/MAX About Town.
Hi everyone, I'm Bini, a realtor with RE/MAX About Town. Looks like we have 52 participants, and we would like to ask you if you wouldn't mind filling out the poll questionnaire. We'd love your feedback, and that would be great. I will get started now. Whoops. So a little bit about me. As I mentioned, work at RE/MAX About Town. I've been in the industry for over 12 years, and I work as a team with my husband, David Archibald. Together, we have over 30 years of industry experience, and the advantages to our client is you get the advice of 2 licensed full-time realtors, and unlike large teams, we do not pass you on to an unlicensed assistant or a junior realtor. You work with us from beginning to the end. And we're also easily accessible because there's 2 of us. We always meet our clients together for the first meeting, even though one of us might lead that client file. We help our clients buy and sell residential properties and their residential investment properties or their rental income properties. We use a personalized approach that's focused on building long-term relationships. And over 95% of our business comes through word of mouth referrals. So repeat clients, friends, family, neighbors, or business and social organizations that we belong to. RE/MAX About Town, a brokerage, is located here in Oakville, and we have 2 offices with over 250 agents. We have a reputable firm that's 30 years old, and we particularly work anywhere from Toronto all the way to Hamilton. Next slide, please. So breaking up is hard to do. We're mindful that you're going through a difficult time and making big changes in your life. And as we all know, sometimes a big change is necessary to get your life back in order. We worked with couples from amicable situations to contentious ones, as well as court-ordered ones where restraining orders were issued. As your realtor, we have a fiduciary duty to handle with care. And what that means is we're obligated to do what is in your best interest at all times. So we remain unbiased, and although we can empathize with you, we try to focus at what your goal is about buying or selling a property. So we're here to make sure that we go through a smooth transition as possible and cause you the least amount of disruption. And selling quickly at the highest possible price is our aim. And what we mean by that is if your house is priced at fair market value and we get you maximum marketing exposure, your house will sell and get the best price. And typically that's within the first few weeks of it listing on MLS and the marketing program is launched. So where to live? You do have options. People take various paths depending on their situation. One partner may choose to stay in the home. If children are involved, you may wish to wait until they finish a certain grade level, for example. One or both parties may choose to rent or move in with friends or family. You could buy out the other partner, or you may choose to sell the matrimonial home and buy two smaller homes. And you might also have, recreational or investment or rental properties that you may wish to sell. Next. So who signs the real estate documents in a sale? So generally, if both parties are entitled, both parties must sign the listing agreements and the agreements of purchase and sale, which is the offer document. However, I have been in situations where there are extenuating circumstances and it's covered off in a prenuptial or a separation agreement, so both parties did not need to sign. So again, this is best to talk to with somebody like Sasha, the family lawyer. For a matrimonial home, if only one spouse is on title, there is a spousal consent section that must be signed on the listing agreement, and again, the offer agreement as well. And common law couples, as Sasha mentioned, who are breaking up do not have the same legal rights. They don't have an equal right to live in the family home or an automatic right to equalize their family property. So again, I defer back to Sasha on that. Next, please. So whether you're buying or selling in the current environment, real estate has remained as an essential service, but it's not business as usual. We are operating under the new COVID-19 guidelines that are mandated by the government, the health organizations, and our regulatory bodies. We cannot hold in-person open houses, but we can continue to show homes accompanied by a licensed realtor. So the good thing is right now you have less disruption. You don't have looky-loos coming off and just going through a Sunday drive, or nosy neighbors walking in. And when buyer agents try to book a listing, there's a pre-COVID questionnaire that our brokerage sends out. And essentially it makes sure that you don't have any symptoms, you haven't traveled, you haven't been in contact with somebody who is tested positive, and they have to sign off on that. And there's also a no touching policy. And what that means is we request that sellers turn the lights on, leave the doors open, so there's less amount of touching when walking through the house. And of course, we practice social distancing and safe hygiene by wearing masks and using sanitizers. So we are here to protect our buyers and sellers. So right now, what's important is quality of buyers. We want buyers to minimize the number of viewings to only those homes they'd consider putting in an offer. So we ensure that they view the virtual tours, we answer all their questions, they do a drive-by of the house, look at the desirability of the neighborhood, amenities, schools, whatever's important to you. We also use digital signatures for all documents, which the real estate industry has been doing for a number of years now anyway. And the offers include COVID-19 clauses to protect all parties. And there are provisions for automatic delay of closing due to pandemic issues. For example, if their land registry has a delay, or if one of the parties, a buyer or seller, contracts COVID-19 and has to be quarantined, there might be an automatic delay that we've built in. So it's not an excuse to get out of the agreement, but we have some provisions to protect you. We also have wire transfer of deposits, so there's less paper handling. You don't have to pick up a bank draft and go into our brokerage. There's also key transfer via lock boxes and so on. So selling your home, if you have come to that conclusion, we want to make sure that you understand we're part of your team and we're here to help. So we ensure that you feel you're working with somebody who cares about your selling needs. We're not here to collect a quick commission. A lot of our clients are multi-generational families, for example. We work with grandparents, parents, and their children, and we want to do a good job so that people refer us to other people they know. We do a full oops, can you go back? We do a full presentation of our services. We discuss all the marketing and sales strategies. We do a home valuation based on comparative market analysis of proven sales and active listings in your neighborhood. We do a walkthrough of the home and provide a property enhancement checklist to get you ready for sale. And we're very mindful of making home improvement recommendations that give you the highest return on your investment. We also have a long list of resources of trusted professionals and tradespeople. So for example, this week, I was able to send a flooring person, a painter, and a landscaper to a client. And these are tried and true people that we know, and they won't walk out in the middle of a job or rip you off in any way. So if we are selling your home, we make sure that we give you maximum marketing exposure. So we're essentially your megaphone to the marketplace. We proactively promote the home on multiple real estate boards. RE/MAX is international, so we have national and international websites. And we know a lot of people migrate to Canada. We have social media, our own websites, and local brokerages that we market to. We develop professional marketing materials. One of our strengths is we're strong negotiators. We structure and negotiate the sale for you. We try to get you the best possible price, favorable terms and conditions, and closing date that works for you. And we manage the entire transaction process. So once an offer is accepted, we make sure deposits are delivered, home inspections are coordinated, delivery of status certificates, revisits. We handle all that on your behalf. And we stay in touch with you through closing date and beyond. And what I mean by beyond is we stay in contact with you if you want any of our tradespeople that you want to use, or we also have a quarterly newsletter that goes out to you. And if you need to know some sales that have recently happened in your neighborhood, we're happy to pass that on to you. Next slide. So buying your home, we can help one or both spouses purchase their separate homes. As you see, it's best to go through someone like Iris Dowling, who's a reputable mortgage agent, to first determine your budget. So we're not running blind. And then we get started with your home search. We discuss suitable timeframes for your move, neighborhoods, style of home, what's most important to you. It might be schools, commuting distance, amenities. And we always recommend that making a needs versus a wants list helps you narrow down your priorities and focus, because there's so many variables out there, and you could have analysis paralysis if you don't do that. We research all the real estate boards to find your ideal home, and once we do find one and put an offer in, once again we negotiate and structure the sale. And that's it for me. I'd be happy to answer any question and answer periods. And I'll pass it on to Barbara Kay of KPA.
Needed to unmute myself there. Thank you, Bini. So I hope everyone's doing well. My name is Barbara Kay, as Bini said. I am the real estate lawyer at Keeney, Panu & Associates here in Mississauga. And Keeney, Panu & Associates is, as you guessed it, KPA. So now that you have a better understanding of the value of the matrimonial home and your proportionate share, as well as what options are available to you in consultation with your mortgage broker and real estate agent, let's say you want to take the plunge and either sell or purchase the matrimonial home. The next big step, if not already retained, is finding a real estate lawyer. So for many people in a separation situation, find this can be a difficult decision. So in a separation involving a mat home, one or two things will happen, and you can see from the slide. One spouse could potentially buy out the other spouse, or both spouses will sell to a third party. I've indicated that I do recommend separating or separated spouses to jointly retain one real estate lawyer when selling to a third party. While this seems like a no-brainer because it will save both individuals in the legal costs associated with closing, sometimes couples in acrimonious or bad splits don't trust this approach, mainly because there is what I like to label an irrational fear that the lawyer will side with one spouse over the other. Any lawyer you retain jointly has a legal obligation to the both of you and will honor that obligation. Everything said to the lawyer by either spouse can be shared by the lawyer with the other spouse. And if a conflict develops, that lawyer will have to step back if it cannot be resolved. So if you are in a situation where your spouse is suggesting using the same real estate lawyer, do not assume that lawyer will not act in your best interest. They are legally obligated to. So having said that, if you are selling to a third party and one spouse is not on title, the titled spouse or the registered owner of the property will need a real estate lawyer, whereas the other spouse who is not on title to the property will need a real estate lawyer for independent legal advice to consent to the transfer. Now, if there is, this is a rare situation, but if there is a signed agreement of purchase and sale and one spouse is buying out the other spouse, you could technically use the same lawyer for the entire transaction. However, I say that with a very significant caveat. The risk of there being a conflict of interest in the situation needs to be considered by the lawyer, because the lawyer is representing the interests of a seller and a buyer, and those are two conflicting parties. While they both may want the transaction to close, there could be situations that occur wherein the advice the lawyer would have to provide to the seller would differ greatly to that of the buyer. So unless the transaction is straightforward, the parties are amicable, and the lawyer seeks consent from the spouses to act on their behalf in spite of the potential for conflicts to occur, this situation is not very likely to happen, but it is possible, so I'm letting you know. Typically, to ensure no conflicts can occur, both spouses will retain their own legal counsel when both spouses are on title and one's buying out the other. So the spouse purchasing the property can retain one lawyer, though, for both their sale and purchase of that same property. Okay. So let's get into the specifics of actually transferring a matrimonial home. So Sasha did touch on this earlier, but I figure I'll give us a refresher. So the first thing to consider is whether the home is in fact a matrimonial home. So under the Family Law Act, it says that every property that is, or if the spouses have separated, was at the time of separation ordinarily occupied by the person and his or her spouse as their family home or family residence is a matrimonial home. Now, as Sasha also indicated, this means that more than one home can qualify as a matrimonial home. You could have two cottages that you split your use of along with a home in Mississauga. All three would be matrimonial homes based under this definition. Now, also with this definition, it refers to a spouse. So that means either of two persons who are married to each other or have entered into a marriage that is voidable or void. So again, as we've alluded to throughout the presentation, this unfortunately means that common law partners are excluded from relying on the Family Law Act when it comes to protecting their interest in a shared home. Now, focusing specifically on the spousal status and spousal protections provided by the Family Law Act, courtesy of those protections, the land title system requires that in all transfers or encumbrances, which is the registration of a charge like a mortgage of a matrimonial home, a spousal statement is required in order to register that document. So you can see from the slide here that I don't know if you can see my cursor, but you have the transferor here. It's a Jane Doe living at 711 Hamilton Road. Yes, I spelled Hamilton wrong. Okay, so here you can see that we've indicated the age of the transferor, which is the current owner of the house who's transferring it. We've indicated that they are not a spouse, and also that the document is not authorized under a power of attorney by the party. So why this is relevant? Beyond the spousal protection provided by the spousal status statement, you need to be of legal age to own property in Ontario. And for POAs or power of attorneys, it's important to know whether or not the transaction is being conducted by one, because there have been issues or greater issues in the past of fraudulent conveyances. So there needs to be additional statements when that's done. But focusing specifically on spousal interests, you'll see quite often the statement, "I am not a spouse." Again, that applies to single individuals, people that are widowed or widowered, and then also common law partners. Alternatively, there are multiple statements available for those spouses that are in a separating or in a situation where they're separating. So if both spouses are on title, the applicable statement is simply so-and-so and I are spouses of one another and are both parties to this document. So by having both individuals named on title to the property, they both need to be on that agreement of purchase and sale. So by that nature, they're both signing off the transfer document. So their consent is already there. Now, if only one spouse is on title, again, as I mentioned before, the untitled spouse, so the spouse that isn't on title, will need to consent, and they'll need to get independent legal advice to know the effect of that transfer. Now, one concern some titled spouses might have, and I'm saying titled spouses quickly, but again, titled spouse is a spouse that owns the property and it's listed as owning that property underneath the land title system. So in the instance that one concern is that the untitled spouse will not consent to the actual transfer if you are trying to sell the property, which would place the titled spouse in a potential breach of their contract. So if you are a spouse that is on title and you have a spouse that isn't on title, one option available to you is to have the untitled spouse sign the agreement of purchase and sale. They would then be accountable for any civil causes of action should they refuse to consent or sign the closing documents. So for those spouses who own property solely and have a separation agreement that relinquishes the former spouse's interest in the home, you also have a statement available to you and there is no need to seek consent for that transfer. Now, separate and apart to the applicable statements found in a transfer document, another protection available to spouses is the designation of a matrimonial home or homes. So remember, you can have multiple matrimonial homes provided they meet the Section 18 definition in the Family Law Act. They had to be ordinarily occupied by you and your spouse and the family, either at separation or prior to, is quite frequently used the house. So if both spouses decide to designate a matrimonial home, any other home that is a mat home, and I say mat home being a matrimonial home, and not designated as such, will not be considered a matrimonial home. So to ensure that homes remain designated as matrimonial homes, the couple would need to register another designation on that other mat home. Now, I might be getting ahead of myself, but a registering a designation means that you're going to a real estate lawyer and you're telling them that you want to register an application general on the specific property, saying that there is a spousal interest in this home. It is a mat home, even though maybe you're not on title, you can do that. But generally, some couples like to do it together for planning. Now, again, as I mentioned, one spouse can designate a matrimonial home without the consent of the other, and this will not actually affect the status of any other mat homes, designated or not. So when it comes to protecting your interests as an untitled spouse, if you're not on title and your spouse is, and your spouse has multiple properties that could potentially fall within the matrimonial home definition, well, I recommend that untitled spouse register an application general to designate those properties as mat homes. This is a great protection that's available to you. I noticed from our poll that quite a few people are separated and not yet divorced. So this may not be an option, but that's certainly for those that are still married and wondering what they should do. This is an option to you. So another concern too that may be raised by the system of statements made in a transfer is what happens when a titled spouse lies about being a spouse. In any real estate transaction involving a transfer or a mortgage, as your real estate agent, I will have the transferor, being the person selling the property, or the mortgagee, person being the person obtaining the mortgage, sign a statutory declaration affirming whether or not they are a spouse under the Family Law Act. So unless I am put on notice that the client has a spouse, it is very possible that a transfer of a matrimonial home could occur. Now, that's extremely scary. So again, that's why designating homes as matrimonial homes is a good idea. But in the event a titled spouse does, in fact, alienate the family home from an untitled spouse by transferring the property, that untitled spouse can seek to set aside the application or set aside the transaction, pardon me, by filing an application with the court. But having said that, if the purchaser in that transaction bought the home in good faith and had no idea it was a matrimonial home, it's very unlikely the court will completely void the transaction and force the home to return to the transferor. So moving forward, while I
operate multiple things. Okay, so I realize my portion of the webinar has relied more heavily on matrimonial homes and spouses rather than common law partners, but as it has been referred to, common law couples do not have legislative protections available to them under the Family Law Act for real property. So as Sasha also said, if one common law spouse owns property, they can do with it as they please. My suggestion for common law couples is to sign a cohabitation agreement before moving in, which outlines what's going to happen with things that you've brought into the relationship, things that you've acquired during the relationship, and what will happen on separation should it occur. Additionally, if one of you is buying property and you see yourself going long-term, maybe see about trying to get both your names on title. Now, the process behind the sale or purchase of a matrimonial home as it pertains to a real estate lawyer is really only distinguished from other transactions by the additional requirement to ensure the property is sold in accordance with the Land Titles Act and the Family Law Act, and that funds are distributed pursuant to an agreement between the parties. Typically, this is a separation agreement. So, thank you, everyone, for attending today's webinar. We are now going to open the floor to the questions. But before we get into that, as a reminder, this webinar is being filmed. So should you wish to speak with us through Zoom on the raise your hand feature, rather than typing a message, please know that the recording will be used in future by KPA lawyers and potentially RE/MAX About Town and Mortgages by Iris. So again, please direct your questions to the Q&A function below. Please don't use the chat feature. It just makes it difficult for us to manage both. Also, if you would like to speak to us directly, again, raise your hand and let's see what everyone's asking us about. I'm just gonna stop.
So I'll read the first question, Barb. Okay, so the question says, how is a jointly owned property divided with both of the owners on title? The property has been paid off. There's no loans, no mortgages on it, but the length of the marriage was approximately 16 months. So this is a really good question. So when it comes to marriages, there's a general rule of thumb that if a marriage is short-term, and short-term for family law would be that a couple has been cohabiting and or married for less than 5 years. So in this example, the person suggests that the relationship or the marriage was 16 months in duration. So even though both people are on title to this property, and I'll assume that it's a matrimonial home, I'm not sure, but I'm going to assume that it is, and the property is fully paid off, when it's a short duration marriage, again, in this case, it's just over a year and 4 months, then oftentimes property division for married couples of short duration marriages could be treated more like a common law relationship. So even though both people are on title, you could look at who contributed what financially. So you'd say, okay, well, who paid the down payment? In this case, the property is paid off, but let's say there was renovations done to the property, who paid for that? Who paid the utilities, et cetera. So I'd have to know more information with respect to the finances, but if both people are on title, but one person in this marriage paid, 90% of the financial contributions, and there was no, let's call it sweat equity of the other partner, then you could make a claim for unequal division of property because it was a short-term marriage.
Thank you. And it looks like we have a raised hand. See about getting Jennifer up here.
You're getting me.
Hi, Jennifer.
Hi, how are you?
Good. How are you? We hope you're enjoying yourself.
I am so far. Thank you.
Great.
I guess my question is for Sasha.
Yeah.
So I sponsored my husband from Jamaica.
Okay.
I owned my home about 5 years prior to him coming.
Okay.
And so now we're separated as of 2017.
Okay.
And we're going through a divorce.
Okay.
So my lawyer is trying to, I guess you were talking about the unjust enrichment.
Yes.
Because he never did contribute to the home. And he's not on the title. I just want to know, with your experience, how do you think, like as far as unjust enrichment,
Right.
if I have a good case with that?
Okay, so just a few more pieces of information. So you said that you are legally married, correct?
Yes.
Okay,
Yes.
and you own the home prior to date of marriage,
Yes.
right? And how long was the marriage?
The marriage, we were married in 2014.
Okay, you said date of
And
separation is 2017, so 3 years.
yes,
Okay,
yes, but he didn't actually come into the country until May 2015.
okay. So it wouldn't necessarily be an unjust enrichment claim. So unjust enrichment or constructive trust claims, that's in the context of common law relationships. So because you are legally married, there would be property division. However, as I said when I was addressing the previous question, when it
Yes,
comes to marriages of short duration, and again,
yes,
short duration in family law is if the period of cohabitation plus marriage is under 5 years, then you potentially could have quite a strong claim that there
okay,
should be unequal division. So in marriages, the default in Ontario, it's assumed that spouses are going to walk away from the marriage with equal property. But if it's a short-term marriage and you can prove that you came into the marriage with this property, that you contributed 100% or the vast majority of the financial expenses towards the property. So you paid the down payment, you paid the mortgage, you paid the renos, you paid the property tax, home insurance, etc., then you could potentially have a strong claim. But if you're going to try and prove unequal division, the onus is on you to raise that claim and to deliver that proof. And you'd have to provide supporting evidence. So you'd have to prove that you paid the mortgage and the other expenses that I mentioned. So
so if
given that it's under 5 years, again, obviously I can't provide legal advice. I can only give legal information, and just knowing,
right.
small snippets of information with respect to your case, I think you could have a strong claim, provided that you have that supporting evidence.
Well, even if I say I did have all that information,
Yeah.
in your experience, would I owe him, would I still have to pay him anything?
Yes, possibly. So when it comes to unequal division, it's very fact specific. It could be very case law specific. So just by way of a very simple example, if it's a 3-year marriage, some judges have said, okay, well, 3 out of 5 years, that's 60%. Like that's right when you break it down in percentages. And so you might owe him 60% of equalization as opposed to 100%. So that could potentially be one way that it's dealt with, but it really depends on the facts, right?
Right. Okay. Okay. Yeah. It's just that I wouldn't be able to sell the home. Like he actually has been what's the word? He was removed from the home
Okay.
last July. He
Okay.
was removed from the home. So he's not even living here anymore.
Okay. But
Yeah.
because it's so even though he's not there, whether criminally or through family law purposes, there could be a restraining order.
Yeah.
It's still a matrimonial home. So even though you owned it prior to marriage, and even though he's not on title, you still need spousal consent to sell the property. So yes, it sounds like if he's not going to allow you to do certain things with the property, then you need to get a lawyer involved, which you mentioned that you have. But as I said, very fact specific, you need documentation, but because it's under that 5-year mark, it sounds like you have a good claim there that he might get something. So he might not get $0 walking away from this property, but he probably isn't going to get 100% because it's under that 5-year mark. And you can show that you paid the vast majority of the finances with respect to the property.
So even though he contributed 0, he can still get something out of the home.
Possibly because it's a marriage, right? So judges and courts in Ontario, there's a stark difference between marriage and common law. And so it's just automatically assumed when people enter into a marriage that there's going to be property division.
Okay.
And the thinking is if you didn't want there to be property division, if you separate some future time, then the option would have been common law. So again, do I think that he would walk away with, $0? Possibly. Do I think he would get 100% of equalization based on the facts that you've described to me? No,
Right.
especially if you've made the vast majority of the financial contributions.
Okay.
All right.
Okay. Well, thank you so much for
You're
your
very, very
answers.
welcome.
Okay. Have a
Okay.
good night.
Take care.
You too.
Okay. So this next question, I think this is more geared towards you, Sasha.
Do we want to, I think I did see a question that wouldn't pertain to me. Okay, so there's a question here. It says, would I be a first-time buyer if my name was put into the mortgage agreement for the last 5 years after living in the house for 15 years?
Okay, so I think this is something that Iris and I could probably tackle. But I am curious, you say you've been put into the mortgage agreement. Does that mean that you are registered on title? Because typically anyone listed in a mortgage is going to be listed on title. So that's the first question. So if you are listed on title, you will not qualify for the first-time home buyers rebate that's available to you should you proceed to buy a home in future. If you're going, let's see, or if you're currently separated and you're going through divorce, I think Iris can handle changes to the CMHC first-time home buyers program. They have a different incentive that might be available to you.
Yes, thank you, Barbara. So if you've been separated for less than 4 years, then you may possibly qualify to use those first-time home buyer benefit programs. But we need to look at more specific information, like the time of separation and what's happening with you now.
Does anyone want to add anything?
Yeah, I think that's what we have for now based off the
Okay.
information provided. But I think we have another raised hand.
Yes, we do.
All right. Okay, just need to unmute yourself.
Yeah, hi.
Hi.
Hi. So my question is this one. We are in a process of divorce, separated almost 10 months ago.
Okay.
We bought a property from the builder. The closing is in September. So am I still, and we did the down payment while we were married, right? Before separation. So am I eligible to 50% of the down payment, or am I eligible to 50% of the growth? Because the property we booked with the builders we purchased from the builders 2 years ago. The property is not closed yet, and this would be our first time home buyer. And my name is not on the property, only my ex name is on the property.
I think this is actually you, Sasha, when you guys are calculating prospective property.
Yep. Okay. So from my family law lawyer perspective, when it comes to property division, and because you are legally married, if I was representing you, for example, then I would need to know what is the value of all your assets and all your debt as of date of separation. So you indicated, and I'm taking notes, that's why I'm looking down. So you had indicated that the property, it was a pre-construction, it was purchased prior to the date of separation. So it was purchased during the marriage, and the closing is not until September of this year, correct?
Yes.
Okay. So in terms of the...
Sorry to interrupt.
That's okay.
That is going to be add on to part of the assets. So don't worry about right now the liabilities, right? So this property is a part of the assets, part of 50% division.
Right. So for example, so you had indicated that the property is in your ex's name. It's not in your name, but it was purchased during the marriage. Yeah. So let's say I'm just making this up, but let's say he put down a $50,000 deposit or first payment for this property, then $50,000 would appear on his portion of the financial statement for a date of separation values. Okay. So essentially you're getting 50% of that. So in this case would be 25,000.
So if during that 2 years, the property gone up to 200K, so it's not that I will get the growth of the half, or it will be, so as per you, I will just get the only 50% of the down payment?
So when it comes to pre-construction property, we only look at, because you don't own it, right? Like we're only looking at ownership. So when you're actually completing your financial statement, you list all of your assets that you actually own, right? So if someone is not on title to the matrimonial home, for example, it doesn't get listed on their financial statement. It would get listed on the other party's financial statement. So in this case, if someone has purchased a pre-construction property, you don't actually own title until closing. And so if you've paid, let's say 3, deposits, one deposit was $10,000, the next one was 20, the next one was 30, then you'd only include the deposits as of the date of separation.
Okay. And so once he get the closing, to suppose in September he get the closing,
Right.
right? And so that's considered a matrimonial home because
No,
No.
not if, so yeah. So the matrimonial home is the property that you occupied as of date of separation. So this property, you don't own it, right? Until September 2020 when it closes, you don't, he doesn't own it. And so right now, again, it's, you don't really own anything. And Barb maybe can jump in, but the property closing after the date of separation, it's not a matrimonial home because it wasn't a property that you occupied as of the date of separation.
if I say that, okay, rather than closing, just sell it, right? And once he sell it, he's gonna make profit on it. So suppose he doesn't get a closing, he said on assignment clause, he sell it and it still makes the profit of this. So how does the division happen on that?
Well, that's first off, if he's allowed to actually assign the agreement. Not a
Yeah.
lot of builders will allow it unless you've negotiated for it.
Yeah, there is an assignment clause.
So they're allowed to assign.
Yes,
Is there a fee for assigning?
yes.
Okay. So there will be various things involved if you want to sign a new build purchase, and that's fine. I also am curious, when you keep referring to the closing in September, are you talking about an occupancy closing or are you talking about a final closing?
I don't know what's the difference.
The difference is in occupancy is you're not actually taking legal title. An occupancy closing is when you are allowed to actually live in the unit per builder's codes, and that's been allowed. Final closing is when you are paying and you get legal title to the property.
Okay.
So that will also help you with assessing at what point you could potentially.
What if he close it? What if he close it and then sell it? Just do the closing?
So if you have everything, as Sasha has indicated, if you have everything sorted based off income at time of separation and what you've paid at time of separation, that's what it should be based off of. Correct me if I'm wrong, Sasha.
No, that's correct. Because it's a pre-construction property, it's treated a bit differently because that asset doesn't exist until after the date of, so everything freezes on date of separation. So when you're looking at ascribing a value to this pre-construction property as of the date of separation, we're only taking into consideration what payments have been made towards that property as of that day. So it's to answer your question, I know it's there's a lot of detail, and unfortunately when it comes to family law matters, it's very, very fact specific. So if you wanted to maybe schedule a consultation with myself or another member of the family law team, we'd be happy to discuss it because there might be additional information that I would need from you in order to adequately address it. But that's just to give you just a general, or at least some information to help.
With you or Barbara?
It could be either. And Barbara and I work very closely together. Our offices are literally across from each other. So both of us could jump in the call if you wanted to chat with one of us.
Yeah, I would appreciate that. I don't want to take everyone's time. I would appreciate that. But this is the only matter I wanted to discuss. That's it.
Sounds good.
Yeah.
Thank you for your question.
Thank you.
Are there any other raised hands right now? Oh, perfect. Ryan's on the ball.
Yes, he is.
Hi there. Do you want to unmute your mic, please? AR, you've been added. You just need to unmute your mic.
We might be having technical difficulties. Okay, let's see if there's anyone else. AR? Any other raised hands there, Ryan? No. No. Okay, so let's move on to maybe some of the other questions provided in the Q&A.
Let's see.
Okay.
Someone said, can we get a free consultation with Barbara? Absolutely.
Yes.
During COVID-19, our firm has suspended consultation fees. So absolutely, you can schedule, you can email, and you could schedule a phone call, or you can schedule a Zoom consultation. I will jump to a question.
Yes, yes.
So the question is, if a house is jointly owned, can one party force the sale of the matrimonial home on the other? So I'm going to assume, because the person mentioned a matrimonial home, that the property is in fact a matrimonial home, which means that the couple that is being referred to is legally married and not common law. And can one party force the sale? Yes, they can. So basically, when it comes to property in a marriage, especially a matrimonial home, there's a few options. So if a couple separates, you can't force a buyout. So if one party wants to buy out the other party, they can of course make an offer, but the other party doesn't have to accept it. So judges in Ontario are quick to say that if neither party agrees to the buyout, then the property is going to be immediately listed and sold. And the net proceeds of sale will be held in trust with a real estate lawyer, such as Barbara Kay. And those net proceeds of sale will not be released to either party unless there is a separation agreement in place. And that's a contract between the spouses, and that's something that I would draft, or a court order that stipulates how the net proceeds of sale are to be distributed.
Excellent answer. Very succinct.
I try.
Okay.
I feel like there's a lot of family law questions.
There is a lot
I'm
of family law
trying to
questions.
just see if there's any that we can give to the other panelists.
Oh, we have a raised hand. Hello, Olga.
And again, just want to remind you that this is being recorded and will be published. So if you're okay with that, you just need to unmute your mic. So you just need to click on the...
So bottom left side, you just need to unmute your mic, Olga.
Okay, can you hear me now?
Yes.
Yes.
Yes, good. Hi, ladies. Thank you for your session.
You're very welcome.
I just have maybe a few questions. I don't know if I'm eligible for a few. I'm in a separation process, and we own two properties, like matrimonial home and matrimonial cottage. I don't know. You mentioned we can possess two matrimonials, right?
Yep.
And I have a question: how can we divide it, split it, or whatever? If I want to get cottage under my possession, how can we calculate the money? For example, let's say cottage cost $300, whatever, and we bought it $150 a few years ago, 10 years ago actually, and now my husband wanna sell it for $350, and if I offer to him $300, how calculated taxes, because usually if you resell something, you pay 30% up growing prices. As I don't know how it's explained. If we bought it $150, it's cost $3,000. That means we have upgrowing $150, and we have to pay 30%, right? It's around $50,000. Or we don't have, how it's calculated. If I don't know, this is I try to explain it, and I don't know how it's properly
It's okay. So I'm gonna jump in.
You mentioned it like matrimonial home. For selling matrimonial home, you don't have to pay taxes for CRA, right? Or you don't pay taxes only for one property? How it's working?
Excuse me, Olga, are you referring to the capital gains tax?
Yes.
I think so.
Yes.
So if you have a principal residence, yes, you are exempt from the capital gains tax. Iris, you might have more input on this, but when it comes to how taxes might apply to two matrimonial homes, I would have to verify with an accountant how the principal residence is defined when it comes to two mat homes. It's because there's two different acts, so they have potentially two very different interpretations.
Okay, I'm gonna dive.
That means I can claim it like a matrimonial home, but regarding to the taxes, it's not like matrimonial home. I mean the equalization taxes.
So as what you do for your taxes is very different to what you do for family law, and Sasha will vouch for this.
Yeah.
So while you might say a home is a mat home, it might not be your principal residence, which is what you would do for your income tax.
Yeah, it's not principal
Yeah.
residence.
Yeah.
Yeah,
But you'd have to, go on.
Okay, sorry. I know there's, based on your description, Olga, there might be a few questions that could be addressed. So with respect to, you had mentioned that you're interested in potentially purchasing the cottage from your husband. And how does that work? So again, when it comes to family law matters in Ontario, a judge is going to say, if you and your husband, your ex-husband, can come up with some sort of agreement amongst yourselves. So for example, I'm just making this up. If let's say you say to him, I want to keep the cottage, you keep the matrimonial home, and he's agreeable to that, then you can absolutely do that. And then it would be advisable to retain a family lawyer to draft what's called a separation agreement. So in this separation agreement, it's going to stipulate that, you're going to walk away from this marriage. You're going to keep the cottage. He's going to keep the matrimonial home. And then whatever other issues there are, that would all be stipulated and detailed in a separation agreement that gets signed by both of you. Both of you would get lawyers and everything is done. If you can't come up with a resolution that's amicable amongst yourselves and you have to go to court, so one of you would start what's called a court application. And basically a judge is going to say, if you can't agree on what's going to happen to the properties, then the properties need to get listed and sold. And the net proceeds of sale are going to be held in trust, as I said, with a real estate lawyer. And then how those get divvied up, it depends on other issues. Like, is there child support? Is there a spousal support piece? So that's where other issues come into play. But when it comes to how you divvy up real estate, either you come to an agreement amongst yourselves or the property is going to be listed and sold.
Okay, I got you. And another question. My ex-husband, he is real estate and he's listing the properties, both actually house and cottage. And what is his percentage as listing agent? Is it, I don't know, am I eligible for half of his percentage, or this is only his percentage, like he's doing the job?
Sorry, do you mean in terms of how much you would get in terms of rental income?
No. He's listing the house and he's listing the cottage.
Oh,
right?
sorry. Okay.
And he pays to buying agent some percentage, and he probably have to pay to himself for selling the properties. I don't know.
So I'll just jump in. Olga, are you asking about the listing agent's commission that he's collecting? Okay. So that, you know what, that's again, typically since it's your property, you wouldn't necessarily collect a listing commission, but because you're separating, he may want to. So yeah, I think that might go under his job title as a realtor. I'm not sure if he'd be able to claim that. Again, Sasha, maybe you can, it depends on the equalization, what is, I guess, considered, his or.
Yeah, so just to answer that from my perspective, again, if the properties are going to be listed and sold, I understand he's a real estate agent, but you don't have to agree to him listing and selling the properties. So oftentimes for clients, what I will advise if a property needs to be sold, then I'll typically suggest that my client propose 3 real estate agents and the other party select one, or vice versa. So you, again, when it comes to anything to do with the properties, because it's a marriage, regardless of who's on title, if you agree that the properties are going to be sold, then you have to also agree on who the agent is going to be. And if you don't feel comfortable with your husband being the real estate agent, despite the fact that that's what he does for a living, then you don't have to agree to that.
Yeah, but
Okay.
this is condition he only to want to sell it, and you know, I don't know, I don't want to fight.
Yeah, so it's up to you. Again, if you want to try and resolve it amicably and you're like, you know what, I don't really want him to do it, but in order to move things forward, that's a good option, then that's fine. But you could always start a court application. If if you feel pressure to do things and you don't agree to it, then that's well within your right. And a judge would say, you find a mutually agreeable real estate agent. And again, typically it's, you would propose 3, he selects one, or he proposes 3, maybe excluding himself, and then you select one.
Court
All
is
right.
closed now.
Yeah,
Thank you.
I know. You're very welcome. Take
Thank you.
care.
Yeah, thanks.
Are there
Okay.
any other hands up, Ryan?
Yep, one moment.
Oh, thanks. Hi, Uzera. You just need to unmute your mic. Uzera, you just need to unmute your mic. Oh, perfect.
Sorry.
Hello.
Sorry, I just have a question. Does the personal law of spouses have got any effect in division of property during separation period?
Sorry, you're going to have to repeat your question.
Does personal law like Muslim personal law, Hindu personal law, or Christian personal law have got any effect during the separation of properties during separation period in division of properties?
Sorry, I'm having a difficult time. Did anyone else catch that? There's just some background noise. It's difficult to hear.
Okay, can I type it?
Yes, absolutely.
Okay, thank you.
Thank you.
Thank you.
Anyone else, Ryan, while he's typing his question? Oh, hi, Nicole. You just need to unmute your mic. Hi, how are you?
So you've spoken a couple times in regard to short marriages. I'm just the opposite. We were married in '96, but we lived together for 2 years before that, and we separated 4 years ago. I've been living in the matrimonial home with my kids since then, paying everything. How does it differ with what I paid after data separation, and how, because it's been more than 20 years, how does that differ?
That's a really good question. So just so I have numbers, you said you separated 4 years ago?
June 15th, 2016.
2016. And has anything been dealt with in your separation?
Nothing.
Nothing.
We do not have a separation agreement.
Okay, so just so I understand, so you're living in the property with the children, he's moved out and he's been out of the property since date of separation?
Yes.
Okay, so that's a really good question. So basically what your question refers to is what we call in family law post-separation adjustments.
Okay.
So the idea is that if I was representing you, for example, I'd want to know, okay, what was the property as of date of separation? So let's just assume very easy numbers. Let's say the property was worth $1 million, okay?
Mm-hmm.
And let's just assume it's fully paid off. There's no lines of credit registered against title or mortgages. And then let's say today the value of the property is 1.2 million. Again, just for simple numbers.
In those past 4 years.
In those past 4 years, yeah. So date of separation, property is $1 million. Today, if you were to sell it, it would be 1.2 million. So the fact that you've been living in the property and you've been paying everything, correct? Mortgage, utilities, et cetera?
Yes.
So basically, what you would need to do is you'd have to calculate post-separation adjustments. So we'd look at, okay, what are the carrying costs of this property? So
Okay.
the carrying costs typically refer to the mortgage payments, property tax, and home insurance. And then as well, if there's been any necessary repairs or maintenance. So if, let's say there was a leak in the roof and you had to fix that. Otherwise, obviously the property would be destroyed. So you'd basically calculate how much you've contributed towards the property during that time.
Okay.
And the idea is, let's say tomorrow you sell the property for 1.2 million, you know, he's not going to get half of it. So it's not going to be split 50-50 because you need to factor in those post-separation adjustments, right? So he technically should have been paying 50% of all post-separation adjustments from the date of separation until the property is either sold to a third party or until there's a buyout. So either he buys you out, you buy him out. So that's kind of like the long and short of it. And then there's other things that come into play. So he could make a claim for what's called occupation rent. So he could say, well, you know, Nicole's had the benefit of living in this property. I'm living, you know, with in-laws, or I'm renting a place. And if that property was sitting vacant, for example, we could have been collecting $2,000 a month in rent. And so Nicole should be paying me for half of that. So every month, post-separation, you should have been paying him half that, or $1,000. So there might be a trade-off, but that's a claim that he would need to raise. So he'd have to make a claim for occupation rent, and then you'd have to make a claim for what are called post-separation adjustments.
Okay. Does it matter the length of the marriage?
No. So the length of the marriage, even though it was a long-term marriage, that could have an impact on, let's say you make a claim for spousal support, which is a very separate issue. Like, let's say you were a stay-at-home mom, or you gave up, some career opportunities for the benefit of his employment. So that's where the length of marriage would come into effect. And when I talked about, as you had mentioned, short-term marriages, so under 5 years in duration, that has to do with more unequal division.
Okay.
But yeah, so in your scenario, the way you describe it, it wouldn't affect post-separation adjustments or the value of the property or anything.
Can I just go back? Is the division at date of separation or date of sale? Because in your example, there was a $200,000 raise in the value. Who gets that credit?
Yeah, so that's the credit. So that example that I was using was talking about if someone comes into the marriage with a property.
Oh, okay.
Yeah.
Okay.
That's good. You're paying attention. I appreciate that.
All right. Appreciate it.
You're very welcome. Have a good night.
Thank you.
You're welcome. Oh, Ryan's on the ball.
Yeah. Hi, Nasli. Just need to unmute yourself.
Hello.
Hi.
Hi.
Hello. I have a question. It's been more than a year that I've been separated from my husband, and he has never lived in Canada, and he's not eager to get into a separation agreement. Now my dad is willing to help me with the down payment of the property, and I'm just wondering if I can keep this money safe. I don't want him to have a claim later on this money because there is no separation agreement between us. I've just sent him an email mentioning my intention that we are separated and there is nothing between us. I'm just wondering if what I'm doing is right to do or not.
Yep. So great question. Because you're separated, you are free to purchase a property. So I always use the example for people, like if you're separated and then 3 days later you win the lottery, you do not have to split your lottery winnings with your ex-spouse because that happened after the date of separation. So you are free to purchase property. The fact, some people argue about the date of separation, but if you have that in writing, if you've sent him a text message or an email, or if you get a lawyer involved saying, basically confirming that what the date of separation is, then that's always beneficial and you are free to purchase property and he would have no claim to it.
But can he claim that because we have been in touch after the date of separation, basically I moved to Canada after we got separated, but we have been in touch through phone or text messages. Can he claim that we have never been separated?
Sure. I mean, he could claim it. Most people, for date of separation, it's a defining moment. There was a text message, police were involved, someone vacated the property. But some people dispute the date of separation, and they often dispute it because maybe they're trying to make a claim for a larger equalization payment. But possibly the safest option is maybe to retain a lawyer. The lawyer sends him a letter. That way there's documented evidence and proof that you separate on a particular day. And just because you've had maybe some correspondence back and forth, that doesn't mean that you've reconciled or that you're back together.
Okay, got it. Thank you very much.
You're welcome.
Okay, so just a heads up, we're heading on 7:54, almost 7:55 p.m. So we are doing this for another 5 minutes. So we will try to get to your questions. If we don't get to them in time, we will follow up. Be sure to send us emails.
Hi, Stev. You just need to unmute your mic.
Yeah. Hi.
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 Hi. Yeah. I just got a question. I've been separated. I live in the basement, but we are in the same house for 2.5 years. So would that count the separation period?
Yeah, that's a great question. I feel like all the questions are directed at me. So you can absolutely be living what's called the test in family law for separation is, are you living separate and apart? So lots of people live under the same roof. I've had clients that still share the same master bedroom. I've had clients that, live separate and apart in the same house for 10 years. So absolutely, you could be separated. And if you're occupying different rooms or different portions of the house, yes, you could be separated.
Oh, how does it prove that we're separate? So we can file divorce right away? We don't have to wait for a year?
Yeah, so you can, in order to request a divorce from the courts in Ontario, you typically have to be living separate and apart for 1 year. And if you would both want to agree on what the date of separation is before you file your divorce application.
Oh, okay. All right. Because since we have child, so how does the child support do it? Like, we want to maintain both custody for 2 children. They are 18 and 16. So we trying to decide that, like, maybe we stay together with 2 weeks for me and 2 weeks with my ex-wife.
Okay, Stev, that's a great question. I'm going to suggest if you wanted to email me, or I know at the end of the presentation, you're going to be getting a link only because your question doesn't touch on real estate in the context of separation, but I'm more than happy. And as I said, we're doing free consultations.
I could email you.
Yes, I'd be more than happy to schedule a phone consult with you. All right.
Thank you very much.
You're very welcome. Take care.
Okay. Hello, Delia. Just need you to unmute yourself.
Thank you. Can you hear me now?
Yes, we can.
Thank you. So I'm under the separation. I'm just starting my separation right now, just a few days. So I'm still like getting a lot of information, right, on what's the next step. So we bought this house where we live together with our kids. He left the house 3 days ago, or I think about 3 days ago. And so I just want to get the information on what are the options for the house that we just purchased last year. And because the term of the mortgage is 5 years, so we just have 1 year here. So that means we need to wait 4 more years for the, to complete the 5-year term. So can we sell the house even though that is the 5 years is not due?
I'm gonna let one of the three of you take it.
From the mortgage point of view, your term of your mortgage is 5 years. Sounds like you're only 1 year into it. If one of you is going to be purchasing another property, and if there's a portability term in your current mortgage, there's a chance that you could port that mortgage in one name only. Otherwise, you'll have to pay the penalty for closing it out early to the lender.
Okay.
So
Okay.
in your mortgage terms, it will tell you what the penalty is and how it's calculated.
Oh, okay. Okay, I see. So the only way to avoid the penalty is to one of us to keep the mortgage, right?
If it's a portable mortgage. So that's why I was talking in the presentation about how important it is to understand the terms of your mortgage. So some mortgages are portable, some are not.
How can I find out if mine is
Portable? It'll be in the terms. So when you signed your mortgage document, your mortgage commitment is a document maybe 6 or 8 or 10 or 12 pages long. And in those terms, it will tell you whether or not it's a portable mortgage and under what circumstance is it portable.
Can I just say something, Delia? It might be worth your while just to get an appraisal from a real estate agent or a value of opinion for your letter, because if the property value has gone up considerably more than the penalty fees, it might be worth your while to sell if you want to get out of it, right?
Yeah, okay. So let's say if we decide to sell the house to a third party, how the amount will be divided, and how can we terminate the mortgage loan to the bank, or how it works? I don't know.
So when you sell the property, and maybe Barbara, you can add on to my response. When on closing day, when you sell the property, let's say your mortgage is $200,000 and you sell your property for $300,000, then the $200,000 gets taken from the selling money and paid back to the mortgage lender, and then you get to keep the balance. So the mortgage is paid out at closing.
Okay.
Yes, that is correct.
But that means even though that we don't have to wait for the 5-year term, right? I mean, if we decide to sell it in, let's say, 6 months or something like that, we can do that?
Delia, yes. So if you do decide to sell in 6 months, you're still ending the mortgage early. So there will still be the prepayment penalty attached to the mortgage. And you can find out what that is in, as Iris explained, the mortgage disclosure statement. In mortgage, like the mortgage commitment. So that's something that your real estate lawyer should have gone over with and given you a copy of when you signed for the mortgage. So you should have that in your files. If not, you can go back to your lawyer and ask for a copy, because we are required to keep it for so many years. Okay.
Okay, but that could be an option, right? So we can terminate the mortgage earlier.
Yes, there'll just be a penalty charge.
Yeah. Okay. Thank you so much.
No problem. Thank you. All right. So we've hit 8:02 p.m. I really hope everyone found the information provided here today informative. I know that we didn't get to all of the questions, and I apologize for that, but please don't hesitate to reach out to us by email. I know, as Sasha's mentioned, KPA is doing free consultations. If you go to our website, you can click a booking called Book a Phone Call. We can have a telephone consult with you. We will also be sending out an email after this with Iris and Bini Billimoria's contact information. So you'll get their email and phone number. So if you have any questions for any of us, please don't hesitate to reach out. We really appreciate you taking the time to come and participate with us.
Thank you, everyone. Have a great evening.
Yes, thank you.
Thank you.